Hello and welcome to our YouTube channel. I'm George, and I'm thrilled to have you join us today. On this channel, we'll be exploring various aspects of Seychelles law, and today our topic is the division of matrimonial property following a divorce. What is the legal definition of matrimonial property? Matrimonial property refers to assets and possessions acquired by spouses during the course of their marriage. In Seychelles, it is governed by the Matrimonial Causes Act 1992 as amended and the Civil Code 2020. The law typically considers such property as jointly owned by both spouses, and in the event of divorce or separation, it may be subject to division or distribution between them. The central principle is equitable distribution, which aims to ensure a fair division of property accrued during marriage. This includes both assets and liabilities. Article 259 of the Civil Code 2020 provides that the court may, in exceptional circumstances where it would be repugnant to justice to apply paragraph 1, make such orders as it thinks fit for the division of the property of the parties, having regard to all the circumstances of the case, and in particular, each party's contribution to the relationship. Section 21(g) of the Matrimonial Causes Act confers a discretion on the court to make an appropriate order of settlement of matrimonial property that must be exercised after consideration of all relevant factors. We will now look at case law and how the court has interpreted the provisions of the Matrimonial Causes Act in cases of division of matrimonial property. Section 21(g) of the Matrimonial Causes Act Cap 124 provides as follows. Financial relief. 1. Subject to Section 24. On the granting of a conditional order of divorce or nullity, or an order of separation, or at any time thereafter, the court may, after making such inquiries as the court thinks fit, and having regard to all the circumstances of the case, including the ability and financial means of the parties to the marriage, make such order as the court thinks fit, in respect of any property of a party to a marriage, or any interest or right of a party in any property for the benefit of the other party, or a relevant child. Where the property is registered jointly in the names of both parties, the court will have recourse to the Land Registration Act. The Land Registration Act in its Section 20A and B provides that interest conferred by registration. Subject to the provisions of this Act, A. The registration of a person as the proprietor of land with an absolute title shall vest in him the absolute ownership of that land, together with all rights, privileges, and appurtenances belonging or appurtenant thereto. B. The registration of a person as the proprietor of land with a qualified title only shall not affect or prejudice the enforcement of any right or interest adverse to or in derogation of the title of the proprietor, and subsisting or capable of arising at the time of registration of that proprietor, but save as aforesaid shall have the same effect as registration of a person with an absolute title. In the case of Singleton Raphael Nancy v.S. Susanna Marinette, Nancy MA 130/2018 arising in DV 117/2015, the property was registered jointly in the parties' both names. However, the court commented that the evidence does not establish whether the applicant and the respondent are registered as the owners of the land with an absolute or a qualified title. However, even if they were registered as proprietors with a qualified title, it would have the same effect as their registration as proprietors with absolute title, except that any person having a right or interest adverse to or in derogation of their title of proprietor, and subsisting or capable of arising at the time of their registration as proprietors, would have the right to enforce such right or interest. There is no evidence that any person has such right or interest. The court considered Article 815 of the Civil Code, which provides as follows. Article 815. Co-ownership arises when property is held by two or more persons jointly. In the absence of any evidence to the contrary, it shall be presumed that co-owners are entitled to equal shares. In the case of Charles v. Charles, CA 1 2003-2005, SCCA 13, the 22nd of June 2005, which concerned an appeal against a judgment given in an application for settlement of matrimonial property consisting of a plot of land and a house thereon, which was registered in the joint names of the parties. The court considered Section 20A of the Land Registration Act, Article 815 of the Civil Code, and Section 21(g) of the Matrimonial Causes Act, and discussed the implications of these provisions. In considering Section 20A of the Land Registration Act, the court stated at paragraph 19, "In my view, therefore, both parties are vested with absolute ownership of the house in question. It follows, in my judgment, that such ownership is in equal shares, as this would accord with the intention of the parties, bearing in mind that they registered the property in question during the height of their love affair. Probabilities are overwhelming, in my view, that the parties intended co-ownership in equal shares. In this regard, it must always be borne in mind that what matters is the intention of the parties at the time when they registered the matrimonial property, and not at the time of divorce. And further, in the same paragraph in regards to Article 815 of the Civil Code, Article 815 of the Civil Code, Cap. 33, in my judgment, also supports the proposition that the appellant as co-owner is entitled to an equal share of the matrimonial house in question as a starting point. The Court of Appeal went on to comment on Section 21(g) of the Matrimonial Causes Act as follows. The use of the word may in this section confers a discretion on the court to make an appropriate order of settlement of matrimonial property. That, as it seems to me, however, is not an arbitrary discretion. On the contrary, it is a judicial discretion that must be exercised after due consideration of all the relevant factors. Although such factors are not, and need not be circumscribed, it is nevertheless pertinent to bear in mind that the court is enjoined by Section 21(g) of the Act to take into account the ability and financial means of the parties to the marriage for the benefit of the other party thereof. The Court of Appeal went on to state that the principle underlying this section is, in my judgment, one of equity designed, as it does, to ensure that no party to a settlement of matrimonial property shall remain destitute, while the other party drowns in a sea of affluence, so to speak. In this regard, it is salutatory to bear in mind what this court said in Renault v. Renault SCA No. 48 of 1998, namely, the purpose of the provisions of these subsections, i.e., 21(g) of the Act, is to ensure that upon the dissolution of the marriage, a party to the marriage is not put at an unfair disadvantage in relation to the other by reason of the breakdown of the marriage, and, as far as such is possible, to enable the party applying to maintain a fair and reasonable standard of living, commensurate with or near to the standard the parties have maintained before the dissolution. In Florentine v. Florentine, Seychelles Law Reports 1990, 141, the parties were given equal shares in the matrimonial home. In Edmund v. Edmund Civil Appeal NO 2 1996, a case which was decided after Florentine v. Florentine, the Court of Appeal upheld the Supreme Court order that the matrimonial home of the parties be held in equal shares. The Court went on to state that, in Lesperance v. Lesperance SCA No. 3 of 2001, this Court laid down the principle that there must be equality of treatment in cases based on similar facts, and thus ordered the matrimonial property in question to be held by the parties in equal shares. That remains a sound principle. One must, however, guard against elevating the principle of equality above the statutory discretionary power given to the courts in Section 21(g) of the Act to make appropriate matrimonial property settlements according to the justice of each individual case. This is more so since in practice it is, in my judgment, hard to imagine any two cases being exactly similar or identical. The Court then went on to state at paragraph 22 of its judgment, on this approach, therefore, I would lay it down as a general principle that equality of shares in cases such as this one must obviously be considered as a starting point for the Court in making a determination under Section 21(g) of the Act. Conclusion. In conclusion, our examination of the division of matrimonial property post-divorce, as guided by the Matrimonial Causes Act 1992 and the Civil Code Act 2020, underscores the profound significance of marriage and divorce within the legal landscape of Seychelles. The Court, in interpreting the provisions of these statutes, consistently emphasizes the pivotal principles of equality, fairness, and equity. The Matrimonial Causes Act 1992, as a cornerstone in matrimonial matters, serves as a guidepost for the Court's approach to the dissolution of marriages and the subsequent distribution of property. The principle of equality is enshrined in its provisions, ensuring a just and impartial division of assets between the parties involved. Moreover, the Civil Code Act 2020 supplements this legal framework, providing additional insights into the equitable distribution of matrimonial property. As we reflect on the Court's application of these principles, it becomes evident that the objective is not merely the allocation of assets, but the acknowledgement of the complex dynamics inherent in marital relationships. The Court's commitment to fairness ensures that each party's contributions, both financial and non-financial, are duly recognized. The emphasis on equity further solidifies the court's dedication to achieving a result that aligns with the unique circumstances of each case. In navigating the intricate terrain of matrimonial property division, the judiciary, through the lens of these legislative instruments, seeks to strike a balance that upholds the sanctity of marriage while pragmatically addressing the realities of divorce. As individuals embark on separate paths, the court's meticulous adherence to the principles of equality, fairness, and equity becomes a cornerstone in fostering a legal environment that acknowledges the intricacies of human relationships. In the pursuit of justice and equity, the Matrimonial Causes Act 1992 and the Civil Code Act 2020 stand as beacons, guiding the court in its solemn responsibility to navigate the delicate intricacies of matrimonial property division with due regard for the principles that underpin our legal system. Do not forget to like and subscribe for more exciting content on our channel. Ciao, ciao.